Well, I see the numbers leveling off, and we have a great turnout again today. Good afternoon, everyone. Thank you so much for joining us this afternoon. My name is Mohsen Manesh, and I serve as the Associate Dean of Faculty Research and Programs, as well as the Director of the Portland Program for the University of Oregon School of Law. And it is my great pleasure today to welcome you to today's Oregon Law Perspectives webinar. The Oregon Law Perspectives series brings the work of our law school's faculty to our colleagues, our students, our alumni, and the broader public. This is the final session of this summer's series, and it's only fitting that we would feature the incomparable Professor Howard Arnett. This is the 5th consecutive year that we've hosted Professor Arnett, so he's officially our Oregon Law Perspectives MVP. Thank you, Howie. Professor Arnett has practiced law for more than 40 years in Arizona and Oregon, representing tribal governments, tribal members, and Native American organizations. His law practice in Bend has included work for tribes on treaty rights, tribal sovereignty, tribal law, development, government-to-government relations, water rights, and gaming. He holds a bachelor's degree from Stanford University, a master's degree from Wellington School of Economics, and a JD from the University of Oregon School of Law. Today, Professor Arnett will provide us with a review and analysis of a major case, Apache Stronghold versus United States, which is currently before the Ninth Circuit and is poised to be headed to the U.S. Supreme Court. The case has significant implications for indigenous rights and religious freedom, and it is really wonderful to have Howie here to talk about it today, about what's happening in the case and what it could portend for Indian law and policy. As our session today unfolds, if you have any questions, please submit them via the Q&A function in Zoom. Only the panelists, me and Howie, can see the questions, and you can remain anonymous if you like. We'll try to get to as many questions as we can before the end of our session today. Finally, for those of you who are seeking CLE credit, you'll receive an email after our webinar asking you for your bar number so that we can submit it to the Oregon State Bar. With that, let me turn it over to Professor Howard Arnett.
Thanks, Mohsen. Good to see everybody, sort of, virtually from on the webinar, and I understand there's quite a number of folks that are interested in this topic. A couple of preliminary things. I've got a bunch of PowerPoints, and those will be available to you afterwards from the law school if you're interested. And before I get to those and start screen sharing, just a couple of preliminary comments. First of all, how this topic came about. As Mohsen said, this is the 5th year, I think, I've done this over the summer, and usually it's a retrospective on the Supreme Court term that just ended for Indian law. Usually there are several Indian law cases, and to the practitioners and the tribes and Indian people, those are always important. This last year, not so much. There was just one case. It was an important case to tribes, and they won it. It had to do with the Indian Health Service, a federal agency, and their funding of tribal healthcare programs. But it was important. It means a lot of money to the tribes, but to a broader audience, just not that interesting. It has to do with some federal statutes. So I thought, what else is out there that would be worth talking about? And then I suddenly became aware of, I hadn't heard about it before, on March 1st, the Ninth Circuit en banc handed on a decision in this case, Apache Stronghold versus United States. And I started to look at it, and I thought, this is a little unusual. It was actually 2 different majority opinions. And the Ninth Circuit was 241 pages, 7 opinions. Ninth Circuit seemed to have tied itself in knots on this case. And it looked to me like, this might be one that could get to the Supreme Court. And there was no doubt that the petitioners, Apache Stronghold, were going to seek cert and ask the Supreme Court to hear it. So we'll get into the case and parse it. And after I do some sort of slides and some information about the background and sort of this area of Indian law generally. But one other thing I want to do before I get to the PowerPoints is a special shout out to Portland attorney Michael Nixon, who is a longtime counsel to Apache Stronghold, been their attorney for many years. And he and I spoke earlier this week, and he was extremely helpful in helping me put together the materials for this webinar. So hopefully Michael is on the webinar, and my thanks to him for helping put this together. So I'm going to screen share now, and we will get to the, let's see here. slides. There we go. Okay. Well, several things I'm going to do, sort of the structure of the webinar. I'm going to start out sort of talking about what are sacred sites generally. Native American sacred sites. Not everybody is familiar with this. So what are they? And then I'm going to talk about this case, the background, a really interesting background to the Apache Stronghold case. It's a fairly long story, and we'll go into that. And then we'll go to the law, and we'll talk first of all about what is free exercise jurisprudence from the Supreme Court, generally speaking, and then what is it in the Indian law context? And we'll look at some cases, one from the Supreme Court and some others from the Ninth Circuit in the Indian law context. And then we'll go to the Apache Stronghold case and parse it all 241 pages, 7 opinions, 2 en banc paragraphs, and somewhat conflicting rulings from within the same case, the same decision from the Ninth Circuit. And we'll talk, if we have some time at the end, briefly about what are the chances that the Supreme Court's going to take this case. I think it's fairly good, but I'm not an expert on those things. So let's talk first of all about sacred sites generally. So I have to move my little screen here. And this is the Cohen Handbook of Federal Indian Laws, description of what are sacred sites. That's the Bible, the treatise in Indian law. And this is what it says. Indian religions are different from most mainstream religions in that they are closely tied to the land. Thus, many natural areas and geographical formations are considered sacred and constitute an integral part of Indian religious activities. And that says it. There are a number of federal laws and federal policies and executive orders relating to Native American sacred sites, and it provides a pretty good structure. Essentially, the federal government, administratively anyway, is obligated to protect and facilitate, consult with tribes in anything they do that might affect sacred sites. National Historic Preservation Act requires the federal agencies to consult with tribes on anything they do, any federal agencies might do that would potentially affect historic properties of religious and cultural significance. 1996 executive order from the Clinton administration required federal agencies to accommodate access to and ceremonial use of Indian sacred sites by Indian practitioners. Then the executive order defines what are sacred sites, fairly narrow definition, and it sort of raises one of the issues that comes up constantly in these cases. And courts raise it is, geography, how big, what's the territory, how big are these sacred sites? So sacred sites are defined as a specific, discrete, narrowly delineated location on federal land. It's identified by a tribe or tribal representatives as sacred. And typically sacred sites in the federal context are on federal lands, national parks, national monuments, U.S. Forest Service land, maybe to a lesser extent, BLM land. But they tend to be striking features of the physical landscape, which is how they often become designated as national parks and national monuments. And in carrying out these administrative responsibilities pursuant to the executive order and other federal law, the federal agencies sometimes get into trouble, at least litigation. They get sued over actions they take with respect to sacred sites. So here are a couple of examples most people might be familiar with. 2 national monuments, Devil's Tower National Monument in Wyoming. It's the first national monument. And there's been an ongoing conflict. It's considered sacred by the Northern Plains tribes, about 20 of them, including some in Canada. And this is in northeastern Wyoming, and it's just a striking feature. It's very impressive, rises out of the rolling kind of high plains of northeastern Wyoming next to the South Dakota border. And there's been litigation. Lots of people like to go to, particularly rock climbers, like to go to Devil's Tower and climb it. And the tribes who regard it as sacred conduct ceremonies at Devil's Tower. And the height of the ceremonial season for the tribes is in June. And so the Park Service, in administering Devil's Tower, decided to impose a moratorium, a closure of commercial climbing permits, guided climbing permits for Devil's Tower in June. That triggered a lawsuit. And initially, the Park Service lost the lawsuit on establishment grounds. The court said their decision by the Park Service to close it in June to commercial rock climbing favored one religion over another. So the Park Service went back and came up with a plan, a management plan that called for climbers to voluntarily not climb during the peak of the ceremonial season. And that's still in place. That was also challenged, but that challenge fell short. It's just a multiple use plan. It's voluntary, it's not mandatory, and it survived. And the same thing happened at Rainbow Bridge National Monument. It's on the Navajo reservation, but it's sacred not only to Navajos, but other tribes in the Colorado Plateau and the Southwest. And it's a really isolated part of the Navajo reservation. That in the background here, you can see that's called Navajo Mountain here. And to get there by land, there's a long trail, difficult trail from the other side of Navajo Mountain that takes you around the mountain and then down to Rainbow Bridge, which is the world's largest natural stone bridge, like 270 feet long. In 1963, the government built Glen Canyon Dam on the Colorado River, and that resulted in Lake Powell behind the dam. And Lake Powell floods right up to Rainbow Bridge. And as a result, boaters can get to Rainbow Bridge very easily. And this is a little bit of the water of Lake Powell, although the water level is actually receding a bit in times of drought. But historically, or since the dam was built and the lake created, you can get there by boat. And lots of boats have done it. Thousands and thousands and thousands of people have, by boat, gone to see Rainbow Bridge. That created management problems for the Park Service. And they tried to control that. And they took a lesson from Devil's Tower and imposed voluntary restrictions, trying to limit the number of visitors and what they did when they were there, where they went when they were there. And so far, it's survived. But they knew if they tried to impose mandatory limits, they may face an establishment claim and might lose it. So this is the sacred site we're talking about today. It's called Oak Flat. That's the Apache language phrase for Oak Flat. I won't try to pronounce it. Apache is an Athabascan language. It's like Navajo. It's highly tonal. And when non-speakers, native speakers like me try to pronounce it, you screw it up and find out you've insulted somebody, or they just laugh because it doesn't come out the way it's supposed to. But this is it. This is the place. It's 6.7 square miles of the Tonto National Forest. It's 60 miles east of Phoenix. And it's already recognized, long recognized as a sacred place. So there's no doubt about that. It's on the National Register of Historic Places. It's a historic district, traditional cultural property for the Western Apache people. This is what goes on there, among other things. This is a sunrise ceremony at Oak Flat. And the Western Apache and the Apache way, young women undergo a coming of age ceremony. And it's a 4-day ceremony. It's called the sunrise ceremony. And every young Apache woman goes through it. And it's really important. It's probably the best known of the traditional Apache ceremonies. And this is a sunrise ceremony going on for Western Apache women at Oak Flat. So that's what happens there, among other things. This is the sort of the lay of the land. This is, oops, go back here a little bit. This is Phoenix. Here's a sort of cutout of the map of Arizona where this is. This is the Tonto National Forest. This is the planned mine site. There's a big copper mine that's planned for this location. It just so happens that Oak Flat sits on top of the world's 3rd largest deposit of copper. Copper is big, obviously, for important mineral for lots of purposes, national defense and other things. And this area of Arizona is long been known as copper country. In fact, it's called the Copper Triangle. There are historic mines of copper mines in this area, and this would be the latest. Oak Flat is 2,400 acre area of the Tonto National Forest. And normally you wouldn't think, well, how can they do a copper mine on a national forest? Well, they can't. But if the national forest is required to convey the site to a copper company, it's no longer national forest land, and they can have the mine. And that's what this statute in 2014 did, called the Land Transfer Act. We'll talk more about that in a minute. And it would transfer this site, the sacred site for the Apache people, to this copper company called Resolution Copper. This map also shows Skunk Camp, because a copper mine eventually becomes an open pit mine, and there's a huge amount of tailings from the mine after the copper is extracted, and that would all be placed in this tailings pile, 10-story high tailings pile over here at Skunk Flat. So what is the issue here? Well, it's the constitutional issue in the Apache Stronghold case about the free exercise clause and something called the Religious Freedom Restoration Act. So it's a statute and a constitutional First Amendment issue. And the question is, does the statute and does the Constitution protect a recognized Native American sacred site from destruction by an open pit copper mine on the Tonto National Forest? And the litigation, as we'll see, is targeted at this statute, which would convey the land from the National Forest Service to the copper company. If you want more on the facts, and by the way, these PowerPoint slides will be available to anybody who wants them from U of O afterwards. There's an LA Times story about a year ago that kind of goes into depth on the controversy, interviews people from the local town that's a big mining town and who want it, and the tribal members who don't. And then there's also an excellent 10-minute video from the Beckett Fund, which is now lead counsel for Apache Stronghold, and they'll be primarily authoring the cert petition. And it's called the Apache Sacred Land Threatened by Mining in Arizona. It's a really good video. So who are the combatants? Well, Apache Stronghold is not a tribe. It's a nonprofit organization composed mostly of tribal members, and they're dedicated to the task of protecting holy sites of the Western Apache people, who mostly come from the San Carlos. This is San Carlos right here, close to the site, and Fort Apache Reservation, which is the home to the White Mountain Apache tribe. And there are several other reservations in Arizona that also have Apache tribal members living there. And so that's Apache Stronghold, and they're led by Wenceler Nosey, 64-year-old former chairman of the nearby San Carlos Apache tribe. The tribe has its own lawsuit, by the way, San Carlos Apache tribe versus Forest Service. It's a NEPA claim, and the FEIS has not been published, so it's stayed. And while this litigation goes forward. On the other side is Resolution Copper. It's an interesting outfit. It's a joint venture led by Rio Tinto, which is an Australia-based multinational mining company. And they're notorious or infamous for destroying a world-renowned Aboriginal sacred site, 46,000-year-old cave in the Junction Gorge area of Western Australia. And it wasn't an accidental destruction. They had a permit from the Western Australian state government, of all people, allowing it. So Australia, in some respects, is a little behind on their sensitivity to indigenous rights. And Resolution Copper is, in the legislation, the recipient of this property, the Oak Flat area that would become the mine. This is Wenceler Nosey, and he's the undisputed leader of Apache Stronghold, former chairman of the Tribal Council of the San Carlos Apache tribe. He's a principal spokesman for the organization. He's, by all accounts, a very impressive and charismatic tribal leader. This is what an open pit copper mine looks like. This is one at Morenci, Arizona, about 90 miles east in the Copper Triangle from Superior and the sacred site. And the mine at Oak Flat, they would start out mining underneath the surface, but eventually the surface would subside and collapse, and it would become an open pit mine. And when that happens, it's going to be a crater 2 miles wide and about 1,000 feet deep. So that's what the Oak Flat copper mine would look like when it's fully developed. So what's the litigation? There are 3 claims made by Apache Stronghold. First is a free exercise claim under the First Amendment. Second is a statutory claim under the Religious Freedom Restoration Act. And the third is an Indian law treaty rights claim. It's an 1852 treaty between the United States and the Western Apache called the Treaty of Santa Fe. And the claim is that that treaty creates a trust responsibility on behalf of the United States, and this statute would violate it. And so it's grounds to stop the statute from going forward. So the timeline is interesting, and to understand this litigation. So first there's the 1852 treaty, and there's the Tono National Forest established in 1905. The importance of oak flat has long been recognized. President Eisenhower signed legislation in 1955 declaring it off limits to mining due to cultural and natural values. Then along comes the statute. In 2005, the Arizona congressional delegation, then led by Senator McCain and Senator Flake, introduced shorthand name for it, Land Transfer Act, requiring the U.S. Forest Service to convey Oak Flat, 6.7 square miles, to Resolution Copper as part of a land swap. So they're not selling the land, they're swapping it out for some land that Resolution Copper already owns. That becomes Forest Service land. So that legislation is sitting in Congress and not really going anywhere for almost a decade. Then in 2014, it's attached as a rider to the 2014 National Defense Appropriations Act, must pass national security defense appropriations, and it's now a rider. There's an interesting backstory on how that happened. It's tragic for the Apache people, but it happened and it passed. It became law. The statute requires consultation with the affected tribes in the area and some mitigation, if possible, as the mine goes forward and is developed. And it also requires compliance with NEPA, National Environmental Policy Act. And however, the statute also says that once the final EIS is published, in 60 days, the transfer happens. Doesn't matter what's in the FEIS. The 60 days, once it gets to that point, the land is transferred. So Apache Stronghold sees that the Forest Service is about to publish the FEIS. In early 2021, they're published, Forest Service said, we're going to do this in a few days. So Apache Stronghold goes to court, files for a TRO and a preliminary injunction. A few days later, the FEIS is issued, and that triggered the 60-day window, at the end of which is resulting in conveyance of Oak Flat to Resolution Copper. Then in 2021, the district court in Phoenix denies the preliminary injunction against the Land Transfer Act for failure to show likelihood of success on the merits, one of the key requirements for a preliminary injunction. Then in March 2021, the Biden administration, it was the Trump administration, 5 days to go, that issued the FEIS for the Land Transfer Act. Now the Biden administration withdraws the FEIS. It's rescinded, and it's still rescinded to this day. They said they've got to do some more consultation and so on and so forth, and it's just rescinded to this day. Well, the district court has denied preliminary injunction, so Apache Stronghold applies to the Ninth Circuit for emergency relief, and that request goes to a motions panel, which is split 2-1, and it denies the motion. So Apache Stronghold then asks, it goes to the merits panel for the 3-judge merits panel, and again, it's split 2-1, and it affirms the denial of the preliminary injunction by the district court. Now Apache Stronghold goes to the Ninth Circuit. Yeah, well, they had a Ninth Circuit merits panel, but now they ask for en banc review. And actually, Apache Stronghold did not ask for the en banc. The judges on the Ninth Circuit asked for en banc review, which seems a little unusual. And this is the March 1st decision, which we'll look at. It's a splintered 9-6-5 decision of the Ninth Circuit, 7 different opinions covering 241 pages. It affirms the district court denial of the preliminary injunction, which is going to be the issue going to the Supreme Court. But it also issues a 2-paragraph per curiam opinion from a different 6-5 majority of the en banc court, which overrules an earlier sacred sites decision in the Ninth Circuit by an en banc court in 2008. And what they did is they changed and added to examples of what constitutes a substantial burden, which is the key element of the free exercise claim under the First Amendment. But they said, so we're changing that part of the earlier en banc decision in the Navajo Nation case, but we're not overruling the outcome. So the outcome is still Apache Stronghold loses. Then Apache Stronghold asked for something I hadn't seen before, which is a request to the entire Ninth Circuit. En banc in the Ninth Circuit is 11 judges. The full Ninth Circuit is 29 judges. And Apache Stronghold asked for the whole Ninth Circuit to hear and review the en banc court's decision. That was denied in May, but one of the en banc judges amended the opinion slightly in this denial of the full en banc review. So cert petition is due on September 11th, and we'll talk about that a little bit later. So what is the free exercise legal framework? And then we'll put it in Indian law context. 2 steps to it. It's pretty straightforward. Step number 1, first of all, you have to show that if you're a religious practitioner, you think your free exercise rights of the First Amendment have been abridged by government action. You have to show that this is a sincerely held religious belief. That's a very low bar. Courts aren't going to question you. You can say however crazy your belief is, they'll probably say, okay, we'll take it. We'll take your word for it. But you then go to the first step. This is where you have to show government action substantially burdens your free exercise of religion. And you don't go to the second step unless you've satisfied the first step. Excuse me. This is where most of the fights are about. And this is examples of substantial burden tend to look in terms of case law at government actions prohibiting or coercing or penalizing religious conduct. And if the court sees that that's what's going on here, you probably have met the substantial burden requirement. Then you go to the second step, which is the burden shifts to the government. The government has to show that there's a compelling reason and interest the government has that overcomes the infringement on religious freedom. That's the second part. Native American sacred sites cases never get to the second part. They fail at the first part, proving a substantial burden. And we'll talk about why that is. The key authorities, not Indian law authorities, but the ones that sort of set the framework for this exercise are, first of all, the Bowen versus Roy court. Actually, Indian plaintiffs, interestingly, but it had to do with a social security number required for an infant, a young child, to get government benefits. And the parents didn't want to get a social security number. They said that would rob the child of its spirit and violate their religious tenets. And the Supreme Court said, that's not a substantial burden. You may, in your own subjective beliefs, feel it's an infringement, but this is essentially non-discriminatory internal government activity requiring a social security number. There's no coercion, there's no penalty. It's only a subjective religious belief. Therefore, no substantial burden and no First Amendment claim. The other two cases, which are the key authorities in this area, they do represent substantial burdens. The Sherbert case involved a Seventh-day Adventist who was fired for refusing to work on Saturday and was unable to get unemployment benefits for not being eligible for employment on Saturday. And the court said that is a substantial burden. That person was required to violate their own religious beliefs in order to get government benefits, which should be available to everybody. It's coercion. They're being coerced. Either give up your religious beliefs to get government benefits or forego the government benefits. That's coercion. Second case is the Yoder case. This is Amish parents in Wisconsin who violated criminally violated the school attendance laws. They said our kids are not going to go to high school. They're going to come out of school at age 14, and state said no, they have to go to school till age 16. And that went to Supreme Court. Supreme Court says that's a substantial burden. They're facing criminal penalties for adhering to their religious beliefs. And so substantial burden was found and claim upheld. So that's the general framework. Indian law context. One big Supreme Court case called the Ling case from Northern California. Road project on Forest Service land would destroy to the point of interfering with the religious practices of 3 Northern California tribes who regard this area as sacred. The high country, they call it. There's no exercise claim. The second case, a big one, is not a sacred sites case. It was a peyote case involving the Native American Church. And in that case, when Native American religious practitioners use peyote, a controlled substance, in bona fide religious ceremonies, if that statute prohibiting the use of peyote is a non-discriminatory general application law, there is no free exercise claim. There's not only no substantial burden, there's just no claim. You're not even in the First Amendment. Congress hated that decision from Supreme Court, caused a great outcry. So 3 years later, they passed the Religious Freedom Restoration Act, which overruled the Smith decision and reinstated the Sherbert-Yoder two-step balancing analysis. Turned out that didn't apply to the states, had something to do with the 14th Amendment and the reach of the 14th Amendment. So Congress came back and passed the 2000 Religious Land Use and Institutional Persons Act, which basically takes RFRA, its sister statute, and applies it to state land use and prisoner claims, which were within the scope of the Constitution for Congress to do that. The last case is one the Ninth Circuit is still struggling with, the Navajo Nation en banc decision, a ski area snowmaking case with treated human wastewater on an Arizona ski area on national forest land, and the religious practitioners, the tribe, said that's going to desecrate the area and make it unusable for our religious practices, and that was held to be no RFRA claim, no statutory claim or First Amendment claim. Is controlled by the Ling decision. So let's look briefly at the Ling case. I always like to know where these places are that are sacred sites. This is an area of the Six Rivers National Forest in Northern California. That's the site of the Ling case. This is way up in the far northeast corner. It's Crescent City here, the Oregon border right up here. And the Forest Service wanted to build a paved road from Gasquet to Orleans through the National Forest, facilitate logging trucks and so on. And it turned out that this area right in the middle of it is called the high country by the tribes in the area, the Karuk and Yurok and other tribes, and said that was going to destroy the peacefulness, the solitude of the sacred site area, and it's going to ruin it for us. And so they had a First Amendment claim. And this went to the Supreme Court in 1998. And this road construction project, because it was a federal action subject to NEPA, Forest Service commissioned an anthropological study, a 423-page study to aid in its environmental impact statement. And the 423-page study said this is a really, really important sacred sites, and the sacred site, the area, and the religious practices of the tribe require solitude, require quiet, and the road is going to do irreparable damage to the religious practices, essentially destroy the religious practices. And the cultural study told the Forest Service, don't go forward with this. You're gonna basically destroy the tribe's religion. Got to Supreme Court. Supreme Court says, no, not so fast. And Justice O'Connor, writing for a 5-3 majority, said this is like the Social Security case. Not like Sherbert and Yoder, not like the Seventh-day Adventists, not like the Amish school case. Building a road on publicly owned land cannot meaningfully be distinguished from the Social Security number in Roy. Government action in both cases just interfere significantly with a private person's ability to pursue religious fulfillment in their own religious faith, but there's no coercion and there's no penalty. Government action just has an incidental, non-discriminatory impact on religion, just like the Roy case in the Social Security number. And then the court tipped its hand in terms of what really was concerned. This is public land. And somehow that makes it different. And maybe public land isn't subject to the same sort of analysis under the First Amendment as other actions that may substantially burden religious practitioners. So that's the problem with Native American sacred sites. First Amendment cannot give citizens a veto over public programs that do not prohibit. That's echoing the language of the First Amendment itself, prohibition on free exercise of religion. Native American practitioners are seeking a religious servitude, a de facto beneficial ownership of more than 17,000 acres of public land. That was a bridge too far for the Supreme Court. It said, even though this road is going to virtually destroy the Indians' practice of their religion because of the nature of the religion, requiring solitude and quiet and so on, that doesn't matter. It's the government's land, and they can do with it what they need to and what they want, as long as it's not discriminatory. But there was a puzzling comment in the majority decision. The court said, now, this might be different if the Forest Service was prohibiting Indian respondents, practitioners, from visiting the area. That would raise a different set of constitutional questions. And then in the Apache Stronghold case, Ninth Circuit sort of puzzling over what that meant. And the majority opinion said nothing. That language was dicta, and it's an unconsidered statement, and they gave it no weight whatsoever. Then the next case, the Smith case I just mentioned briefly, the peyote decision was a stunning outcome. Most people didn't expect it. They thought they would apply the substantial burden offset by compelling government interest test. But in fact, the Supreme Court said, well, as long as there is a generally applicable non-discriminatory law that may have the effect of denying somebody the right to exercise their religion, that's okay. That's not a First Amendment religious free exercise claim. It's not covered by the First Amendment, as long as it's generally prohibited by general application law, as the Oregon criminal prohibition on the religious use of peyote was. Congress responds, as I mentioned, 3 years later in the Religious Freedom Restoration Act, which expressly brings back the Sherbert-Yoder balancing test and says, even where there's a generally applicable law that would have the effect of burdening religion, they now have to justify it. It now has to be justified if it's in the Sherbert-Yoder framework of substantial burden. And then there was another statute later that prohibited states from banning criminally the use of peyote in legitimate Native American church services. And then, of course, the later statute, the sister statute that extended RFRA to state land use and prisoner cases. Smith case is fascinating. Our own Professor Epps wrote a great book about it called To an Unknown God. I highly recommend it. Very readable. Professor Epps is a journalist as well as a law professor, wrote for The Atlantic for many years, covering the Supreme Court. So I highly recommend it. This is the case, the other earlier Ninth Circuit case involving sacred sites. San Francisco Peaks are in northern Arizona, Coconino National Forest, Colorado Plateau, sacred to 13 Native American tribes. And this is the ski area on San Francisco Peaks, Arizona Snow Bowl, just outside of Flagstaff. San Francisco Peaks case involved the U.S. Forest Service permit to use artificial snowmaking equipment, which got its water from treating human wastewater. And this case, to its those who want to give it a derisive nickname, is referred to as the yellow snow or the poopy snow case. And the tribes say the use of human wastewater will desecrate the area and depreciate its use for religious purposes. And the 10th Circuit en banc close decision, 6-5, said, no, it's not covered by RFRA because RFRA restored the compelling interest test compelling interest test from Sherbert and Yoder, but this is not at issue here. And it said it's not a substantial burden. Requires RFRA by bringing back Sherbert and Yoder the same kind of substantial burdens that existed in both those cases, coercion or penalty. And this is just the use of human wastewater as treated wastewater as snowmaking, and that's not prohibiting anybody from going there. It just changes the landscape. And going on, like as Judge Ling and or Judge Connor and Ling said, by the way, this is public land. Giving one religious sect a veto over the use of public parkland would deprive others of the right to use what is, by definition, land that belongs to everyone. And Judge Fletcher, generally a very pro-tribal judge on the Ninth Circuit, dissented and argued that RFRA provided greater protection for religious practices than the pre-Smith cases, the Supreme Court's jurisprudence. So Apache Stronghold, what did it do? First of all, there's a 2-paragraph en banc per curiam decision, 6-5 majority. They essentially overruled part of the Navajo Nation decision by saying substantial burden under RFRA is not just coercion and penalty. It can actually include, an example would be preventing access, could be an example of a substantial burden. So they modified, essentially overruling that part of the Navajo Nation decision. But, and that was by 6-5. Then the 6-5 majority flipped, and the other part of the per curiam opinion and most of the rest of the en banc decision says, but we uphold the Navajo Nation decision that that says the tribes lose and they don't have a RFRA, our First Amendment claim, by sort of saying, yeah, this in Apache Stronghold, this doesn't involve coercion, it doesn't involve penalty, it doesn't deny any practitioners equal share of benefits, and therefore Navajo Nation's outcome is not overruled. And essentially, they said Ling case controls the Gull Road case from Six Rivers National Forest. That was prior to Smith, prior to RFRA, and that's still good law, still good law. And that's essentially what controls here. That's what they said in their analysis of the free exercise claim by Apache Stronghold, said this is Ling. It's just Ling all over again. It's indistinguishable from Ling. And Apache Stronghold seeks not freedom from government action prohibiting the free exercise of religion, but rather a religious servitude over 6.7 square miles of Tonto National Forest, confer on tribal members de facto beneficial ownership of a rather spacious tract of public property. That's quoting Ling. And this is the line drawing, or what are the boundaries specter that comes up in these Native American sacred sites cases. How big is it? How far? What we set a legal precedent saying this land is subject to free exercise claim and isn't offset by compelling government interest. How far can that go? It can be used elsewhere where it's a huge sacred site. The Navajo tribe and other tribes in northern Arizona, by the way, regard the entire San Francisco Peaks as a sacred site, not just where the ski area is. So like Ling, it involves disposition of government real property. Like Ling, the government's conduct of its own affairs, deciding to sell or trade the land to a copper company. No tendency to coerce, no discrimination, no penalty or denial. And there's no prohibition, even though the sacred site is going to be destroyed, it'll become a crater, and won't be able to do the sunrise ceremonies anymore for young Apache women. But I guess that's not prohibiting. And that's what eventually what the dissent said. The RFRA claim, similar, rejected. There is no broader protection created by RFRA. Prior to the case law, did it create a practical effect of displacing by statute the pre-Smith decision in Ling? In other words, did RFRA modify Ling as well as Smith? The answer is no. RFRA only intended to resurrect the Yoder-Sherbert framework for what is a substantial burden, and that's it. Rover ruled the Smith case, nothing more. And it just did not change the pre-Smith case law. Therefore, Ling is still good law, and it absolutely is on point with the Apache Stronghold facts. The treaty claim was dismissed rather in a perfunctory manner that said there's no trust obligation created by the treaty language. And even if there was, Congress abrogated the treaty. Congress has plenary power. They can do that, and they did it in the Land Transfer Act. That abrogated any possible treaty claim from the 1852 treaty. But the case law is quite clear that a congressional abrogation has to be clear and manifest, that that's exactly what Congress intended to do, and they knew they were doing it. The Land Transfer Act does not mention treaty, doesn't mention religion, but Ninth Circuit said they thought about it, or somehow the statute goes far enough to constitute an abrogation. So the dissent is dismissive. This is the 6-5 majority en banc decision. Tragically errs in rejecting Apache Stronghold's RFRA claim solely based on Ling. Ling does not answer the question here. Where are we faced with a government action that result in a massive hole, obliterating Oak Flat, categorically preventing the Western Apaches from ever practicing their religion? Effect will be immediate and irreversible. RFRA preventing religious adherents from engaging in sincere religious practices undeniably constitutes a substantial burden. And RFRA's plain text compasses such claims, and Supreme Court and our jurisprudence have long so recognized.
Howie,
Yeah.
we're at 12:47, and I want to make sure we save some time for
Okay.
audience Q&A. So
Okay.
let me stop you there. And we have a couple of questions or comments in the Q&A. But if you have questions or that you'd like Howie to address, please enter those into the Q&A now. Let me start with one question that I have, Howie, which is, what are the chances you think that the U.S. Supreme Court would grant cert in this case? What kind of considerations might the court take into account in deciding whether or not to grant cert? I know I was involved in a case in the Ninth Circuit that had en banc review, and we were hoping the Supreme Court would grant cert because we wanted Supreme Court precedent, but the losing side didn't want to petition for cert because they were afraid of what would happen at the Supreme Court. So I'm curious what your thoughts are on what happens next here.
Okay, well, that actually is my last slide, and
okay.
I would let's see. I think it's I still have it there. Screen share. Here we go. It's not doing it. Anyway, well, several factors. One is I think the chances are pretty good, and I'm no sort of seer on these things. For one thing, their counsel, chief counsel, lead counsel, Beckett Fund, has an incredible record of pre-exercise cases, Supreme Court, 8-0. And that's impressive. And then there was a huge lineup of amici in the Ninth Circuit, kind of like there was in the Smith case. Everybody from the LDS Church to the Notre Dame University Religious Freedom Clinic, interestingly, where Justice Comey Barrett used to teach, the Jewish Federation for Religious Freedom, and so on and so forth. So there will be a strong lineup, an impressive lineup of amici supporting cert. There's also an arguable conflict with the 10th Circuit in a case that Judge Gorsuch decided when he was on the 10th Circuit, now on the Supreme Court. And in that decision called Yellow Bear, it's a state prisoner case from Wyoming, he found that denying a Native American practitioner his access to religious practices, namely a sweat lodge on prison grounds, that's a substantial burden. So preventing access, he recognized, and the 10th Circuit recognized, is in fact an example of substantial burden. And, blowing up a sacred site and creating a huge crater would seem to be preventing access. You can't do the sunrise ceremony anymore after that. So I think those factors weigh in front of it. If you had cert 4 votes, I'd say Gorsuch, Sotomayor, Kagan, and maybe Brown Jackson. And Amy Barrett would be interested as well.
Yeah, it looks like there are a few factors there that would suggest this would be cert-worthy. So we've had a couple of comments and questions come in through the chat. I'll just read them to you, Howie, and then you can respond. One question asks, what happened to the 1955 law that prohibited mining at Oak Flat?
It's no longer, that is part because it was Forest Service land, but it's superseded by the Land Transfer Act. So.
I see. And here's a comment from Michael Nixon. One of the interesting aspects of the Apache Stronghold's Ninth Circuit en banc panel is that the presiding judge, Murguia, was on the 3-judge panel that ruled 2-1 against the stronghold, but with a scorching dissent by Judge Berzin. But after en banc review and oral argument, Judge Murguia changed her view and actually wrote the 5-judge dissenting opinion in the en banc decision.
That is interesting. Mike has lived this case for a long time, so he's got the inside knowledge. He's got the backstory on the 2014 writer as well that enacted the Land Transfer Act, which is interesting, tragic, but interesting.
Here's another question. Do you believe the current Supreme Court of the United States can consistently apply a standard of review for free exercise of religion in favor of religious practices, or is the Supreme Court's unique historical and constitutional role in deciding all things federal Indian law too much for this current court to review Native American religious practices as on equal footing with other religious practices, for example? I've heard that some unusual news headlines about Oklahoma law allowing Bibles to be taught in public schools and Louisiana law mandating the 10 Commandments be displayed in public schools. So the question is, do you think the current court can view Native American religious practices on par with other Western religious practices?
Part of them probably yes. Part of them probably no. And I could sort of offer a guess as to which parts. Our colleague Professor Epps probably has a better view of that. So I honestly don't know the answer to that question. The courts have struggled, I think, with the sacred sites case. It's just the idea that landscape is the basis of a religion is problematic. This religious servitude specter and tying up public land, thousands and thousands of acres, and giving this group of Native American practitioners a right to control that land and override government decisions. I think that's problematic for a lot of judges, but judges are not Native Americans and practitioners of these religions for the most part, virtually entirely.
Fair enough. So we still have time for more questions if anyone wants to put them into the chat. I'll take one question, which is, I think you said that the deadline for applying for cert is September 11th. Is that correct?
Yeah, it was extended. Justice Kagan entered an order extending the deadline, and they're
okay,
working on it now.
Okay, and do we know a cert petition will be filed?
Yes,
okay,
absolutely.
Okay.
Press release from Beckett Fund said they would.
Okay.
So I know it's in the works.
Very cool.
This may be the subject of next year's, if it gets filed, it gets accepted, it gets heard, decided, this might be what we're doing a year from now, is talking about it.
Well, that would be an interesting follow-up for sure. So I'm not seeing any other, I see several thank yous for the presentation. Go ahead.
Barbie, did you have something?
Yes, I did see an additional question come up. Is it public, is the public land by yet going to be destroyed by a private corporation? How does the public land idea by the courts, O'Connor, take into account what the public actually wants?
I don't know the answer to that question. I think there's a bill in Congress now to repeal the Land Transfer Act. It doesn't have much time to get enacted. And obviously, judging by the action of the Trump administration and the Biden administration regarding to the FEIS, which is the triggering mechanism for the land transfer 60 days later, I suspect at least at one level, at that administrative level, this election in 2 months may have a lot to say with how this thing turns out.
Howie, another question. How do you see the potential outcome of this case as influencing other contested sacred site cases such as Thacker Pass in Nevada?
Well, if it comes out in favor of the tribes, that means that destroying the location, the landscape of the sacred sites does represent a substantial burden. And that's been the biggest hurdle in sacred sites cases and Native American religious practice cases, is establishing that. And so then the government has to justify it. I mean, how important is it getting to the lithium at Thacker Pass? And are there other lithium mines where they can get the lithium and build, electric car batteries without destroying the Native American sacred site, that government would have to justify it once a substantial burden is shown. That would be interesting whether they could or not.
So that could be a potentially significant outcome if this case gets decided by the Supreme Court.
Yeah.
Well, very good. Seeing no more questions, we're getting close to time, so I'll wrap it up by thanking Professor Arnett for the interesting presentation today, and we hope to make it 6 years in a row next year with you coming back and giving us the update on what the Supreme Court ultimately winds up doing with this case. With that, that wraps up today's webinar. Thank you again for everyone who participated. It's great to see such a wonderful turnout and such an engaged audience in our Oregon Law Perspectives webinar series. Look out in your inbox for future Oregon Law Perspectives webinars. We hope to see you at some point in the near future in another one of these sessions. Thank you again and have a great rest of your day.
Thanks, everybody. Bye-bye.